Good morning to all of you. I hope all of you are doing great. तो चलिए आज के डिस्कशन को हम लोग शुरू करते हैं. Today we are going to discuss 2018 shift 2 question paper of MP Civil Judge Prelims exam, in which in the last classes we have discussed till question number 40. Today we are going to discuss from question number 41 onwards. तो चलिए आज के डिस्कशन को हम लोग शुरू करते हैं. अगर अभी तक आप लोगों ने हमारे चैनल को सब्सक्राइब नहीं किया है तो प्लीज गो एंड सब्सक्राइब टू अवर चैनल एंड डोंट फॉरगेट टू प्रेस द बेल आइकन. And apart from this thing, like we have started MP Civil Judge Prelims crash course in which we are providing 10 plus mocks, recorded video lectures, one-on-one mentoring and doubt clearing sessions. Do check it out. Link is in the description. Now, चलिए आज के डिस्कशन को हम लोग शुरू करते हैं. फर्स्ट क्वेश्चन, क्वेश्चन नंबर 41. So this question is from Specific Relief Act. In Specific Relief Act, all other words and expressions used but not defined, then their definition and meaning would be the same which has been defined under option A, Transfer of Property Act 1882, option B, Civil Procedure Code 1908, option C, Indian Contract Act 1872, and option D, Easement Act. So what should be the correct answer? Question number 41. Now, if you people have followed up the definition clause of Specific Relief Act, you will be able to find the answer of this question. So what should be the correct answer of this question? Yes, can anyone tell me? They are simply stating that all the words and definitions which are not defined specifically under your Specific Relief Act, then for those words and expression where we can go for which act? So its correct answer will be C for Calcutta. That is your Indian Contract Act 1872. Yes, Vinny ji, you are correct. 41 ka C is the correct answer. Question number 42. What is true in respect of mandatory injunction? What is true in respect of mandatory injunction? Option A, compels the performance of certain positive acts. Option B, is awarded when the temporary injunction is meaningless. Option C, is retrospective in nature as restore the things to their former conditions. And D, all of these or all of the above. So this particular question is belonging to your section 39 of Specific Relief Act. So they are simply asking which of the following statement is true regarding mandatory injunction. Compels the performance of certain positive acts. Option A. Option B, is awarded when temporary injunction is meaningless. Option C, is retrospective in nature and as restore things to their former conditions. And D, all of these. So its correct answer is D, all of these. Yes, Vinny ji, again you are correct. Next question is question number 43. Specific performance of contract may be ordered where? Option A, there exists no standard for ascertaining actual damage by non-performance of the act to be done. Option B, compensation is adequate relief. Option C, the performance of the contract involves performance of continuous duty which the court cannot supervise. And option D, the contract by its nature determinable. So what should be the correct answer? Yes, Ankita Gupta ji, 42 ka D is the correct answer. Question number 43. What should be the correct answer? Specific performance of a contract may be ordered when option A, there exists no standard for ascertaining actual damage by non-performance. Option B, compensation is adequate relief. Option C, that is performance of a contract involves the performance of a continuous duty which cannot be supervised. Option D, the contract by its nature is determinable. What should be the correct answer? 43. Yes, A is the correct answer, Vinny ji. You are correct. Now, let's move further. Next question is question number 44. Now, this particular question is stating now, the specific performance of a contract may be obtained by option A, Any party thereto. Option B, the representative in interest of any party. Option C, the principal of any party thereto. And option D, all of these. So what should be the correct answer? The specific performance of a contract may be obtained by option A, any party thereto. Option B, the representative in interest of any party thereto. Option C, the principal of any party thereto. And option D, all of these. So 44, its correct answer is your option D, that is all of these. So all of these statements are correct in nature. Now, next question. Question number 46, that is again from your Specific Relief Act. Yes, 44 ka Vinny ji, D is the correct answer. 45, under section 6 of Specific Relief Act, a suit for recovery of possession of immovable property. Yes, Ankita Gupta ji, 44 ka not B, D is the correct answer. Under section 6 of Specific Relief Act, a suit for recovery of possession of immovable property may be brought within dash from the date of dispossession. So this particular question is quite common from Specific Relief Act. They are simply asking that under section 6 of a Specific Relief Act, a suit for recovery of possession of immovable property may be brought within dash from the date of dispossession. Option A 6 months, option B 3 months, option C 1 month, and option D 3 years. So what should be the correct answer? A, B, C, D. Question number 45. Yes, A is the correct answer. Vinny ji, you are correct. Now let's move further with the next question. Next question is stating an order or decree passed in a suit presented under section 6 of the Specific Relief Act is option A, appealable, option B, reviewable, option C, neither appealable nor reviewable, and option D, both appealable and reviewable. So what should be the correct answer? An order or decree passed in a suit presented under section 6 of Specific Relief Act is option A, appealable, option B, reviewable, re-reviewable, option C, neither appealable nor re-reviewable, option D, appealable and reviewable both. What should be the correct answer? Question number 46. Yes. So this question is again from your section 6. Its correct answer will be C for Calcutta, that is neither appealable nor reviewable. याद रखिएगा, an order or decree passed under section 6 which is talking about granting of possession to a person wrongfully dispossessed. That particular order is neither appealable nor reviewable. It is only revisable. Only revision can be done, right? Yes, Vinny ji, you are correct. 46 ka C is the correct answer. Next question is question number 47. In which of the following cases section 10 of Limitation Act applies? Option A, trust arising by operation of law. Yes, Ankita Gupta ji, 46 ka C is the correct answer. Now, in which of the following cases section 10 of Limitation Act applies? Option A, trust arising by operation of law. Option B, trust for a specific purpose. Option C, implied trust, and option D, all of these or all of the above. So what should be the correct answer? This is the question from Limitation Act. So if you people have followed up section 10 of Limitation Act, you can easily answer this particular question. 47. Under section 10, Limitation Act applies for trust arising by operation of law, trust for a specific purpose, implied trust, and all of these. So 47, what should be the correct answer? Yes. Question number 47, what should be the ideal answer? 47 ka B is the correct answer. B for Bangalore. That is trust for a specific purpose. Only for that, the section 10 is applicable. Next question is your question number 48. The limitation to obtain a declaration of title of immovable property. Option A, 2 years when the right to sue first accrues. Option B, 3 years when right to sue first accrues. C, 1 year when the right to sue first accrues. And option D, 12 years when right to sue first accrues. So what should be the correct answer? 2 year, 3 year, 1 year, 12 year. Declaration of title of immovable property. Declaration of title of immovable property. So when there can be the declaration of title of immovable property? Yes. Just let me know quickly. Question number 48. What should be the correct answer? its correct answer is your B for Bangalore. That is 3 years when the right to sue first accrues. 3 years when right to sue first accrues. Now, next question is your question number 49. Period of limitation for the enforcement of a decree granting a mandatory injunction is. Period of limitation for the enforcement of a decree granting a mandatory injunction is option A 12 years, option B 1 year, option C 3 years, option D no limitation period is prescribed. Question number 49. Period of limitation for enforcement of a decree granting a mandatory injunction. Sir, the screen is not visible. Ankita ji, I hope now it will be visible to you now. The period of limitation for enforcement of a decree granting a mandatory injunction is option A 12 years, option B 1 year, option C 3 years, and option D no limitation period is prescribed. So 49, what should be the correct answer? Yes. What should be the correct answer in reference to question number 49? Just let me know quickly. Yes, 49 ka Ankita Gupta ji is saying C. Yes, Ankita ji, C is the correct answer. If you will read article number 135, it is simply stating that the period of limitation for the enforcement of a decree granting a mandatory injunction is 3 years. Next question. When once the time has begun to run, no subsequent disability or inability to institute a suit or to make up an application stops it. This particular statement is provided under which section of Limitation Act? Option A, Section 4, option B, Section 9, option C, Section 10, and option D, Section 11. So which section of Limitation Act specifically provides that once the time has begun to run, no subsequent disability or inability to institute a suit or make an application stops it? It is provided under which section? Section 4, Section 9, Section 10, and Section 11. What should be the correct answer? 4, 9, 10, 11. What should be the correct answer? Question number 50. Yes. Jaldi se bataiye. Question number 50. What should be the correct answer? 50 ka yes. Vinny ji is saying C. No, its correct answer will be B, Vinny ji. That is, this specifically under Section 9 of Limitation Act, this particular statement is contained, right? Next question, question number 51. Now, this question is from your Accommodation Control Act. Accommodation Control Act, right? So, the question number 51, what they are stating, where an order for the eviction of tenant is made under Section 12 on the grounds of the specified in clause E of subsection 1, the tenant is entitled to the amount by way of compensation from landlord. Yes, Ankita Gupta ji, section 11. For which question you are stating section 11, Ankita ji? Now, so option A, double the amount of annual standard rent of the accommodation. Option B, amount of annual standard rent. Option C, not entitled for any amount. Option D, as per the order of the court. So what should be the correct answer? Where an order for the eviction of tenant is made under section 12 of on the grounds of specified under clause E of subsection 1, the tenant is entitled to amount by way of compensation from landlord. So which amount can be claimed by the landlord, by the tenant from landlord? So its correct answer 51 ka correct answer is C, that is not entitled to any amount, right? Not entitled to any amount. So 51 ka C for Calcutta is the correct answer. Now next question, question number 52. MP Accommodation Control Act. Essential supply enjoyed by a tenant in respect of accommodation let to him is cut off by the landlord, who will make an order to restore such supply. Option A, collector. Option B, civil court. Option C, rent controlling authority. And option D, municipal corporation or municipality, as the case may be. So which of the following authority is going to make an order for restoration of supply of basic things which has been cut off by the landlord against the tenant? So what should be the correct answer? A, collector; B, civil court; C, rent controlling authority; and D, municipal corporation or municipality, as the case may be. Yes. Question number 52. Yes, Viniji, you are correct. C is the correct answer. That is rent controlling authority. Next question is question number 53. Again from MP Accommodation Control Act. For a construction which has materially altered the accommodation to the detriment of the landlord. Yes, Ankita Gupta ji, you are correct. A landlord's interest, or is likely to diminish its value substantially by the tenant. Option A, oral permission from landlord is sufficient. Option B, written permission of landlord is necessary. Option C, permission has to be taken from the rent controlling authority. Option D, no such permission is required. Question number 53. So if you will read your section 12(1)(m), section 12(1)(m), if you will read, you will be in the position to find the answer of this question. Oral permission from landlord is sufficient. Option A. Option B, written permission of landlord is necessary. Option C, permission has to be taken from rent controlling authority. And D, no such permission is required. So what should be the correct answer? Its correct answer is B for Bangalore. That is, written permission of landlord is necessary. Written permission of landlord is necessary. So 53 ka B is the correct answer. Yes, Viniji, you are correct. Next question, question number 54. The provisions of MP Accommodation Control Act applies to option A, only municipal corporation area. Option B, only municipal corporation and Nagar Palika area. Option C, only those areas as specified in the first schedule. And option D, whole of Madhya Pradesh. So the provisions of MP Accommodation Control Act applies to only municipal area, ठीक है, only municipal corporation and Nagar Palika area, only for those areas as specified in the first schedule. And option D, whole of Madhya Pradesh. So what should be the Zahid Safi ji, sir, UP Judiciary. Zahid ji, most probably we can expect that in the month of October, most probably in the month of October, you will find the UP Judiciary ka notification, and the exam may be conducted in the month of November. That is my like observation. I cannot be very much sure. 54, yes, Viniji, you are correct. C is the correct answer. Right. Next question is question number 55. वो whole MP का already notification is out, and MP most probably may conduct its exam in the month of April and or June, May starting. Right, Zahid ji? सर बहुत ज्यादा लेट हो गया, हो जाएगा. Zahid ji, I am telling you on realistic ground, right? So here you have to understand, when I'm talking about UP Judiciary, firstly, the elections are going on. Firstly, elections result will be out. Then the member of Legislative Assembly will be elected. Then they will start working. Then they will pass all the important bills and notifications. And after that, they will think on administrative thing. So looking into that scenario, I'm stating October, right? Question number 55. MP Accommodation Control Act. Tenant may be evicted on the ground of bona fide need of landlord for residential purpose, but the need does not extend to A, his son's need. Option B, need of other family members. Option C, need of any person for whose benefit accommodation is held. Option D, need of any other tenant paying more rent. So 55 ka yes, Viniji, you are correct. D is the right answer. Let's move towards next question, that is question number 56. This question is from MP Land Revenue Code. The question is, does khasra is a Hindi word, ठीक है? Khasra actually means a sort of map. Khasra actually means a sort of map. Does the khasra entitles does the khasra entries confers titles? Option A, yes, name of Bhumiswami entered in it. Option B, no, entry in revenue record is only for the purpose of land revenue. Option C, yes, it creates substantive rights. Option D, yes, entry shall be presumed to be correct. So 56 ka what should be the correct answer? Yes, Zahid ji, I am preparing for IAS and PSC. I can't wait for October. Am I right, sir? Zahid ji, I won't suggest you, if you are preparing for IAS and state PSC, that you should wait for October. You should continue your preparation with IAS and PSC. Meanwhile, you can side by side prepare law subjects, and whenever the notification comes out, you can always follow up MCQs and move further, right? Vinny ji is saying 56 ka D. No, 50 g, Vinny ji, I'm really sorry. 56 ka B for Bangalore is the correct answer. That is, no entry in the land revenue is only for the purpose of land revenue. It is for no other purpose. Next question. Question number 57. Whether a non-tribal acquires Bhumiswami right of revenue land by will executed in his favor by aboriginal tribe. Option A, no permission of collector is required before execution of will. Option B, yes, the permission of collector is required. Option C, yes, being a Bhumiswami of land revenue, rights of aboriginal tribal are absolute. Option D, yes, acquiring of Bhumiswami right by will is not transferred. 57. What should be the correct answer? Yes, A for Ahmedabad is the correct answer, Viniji. No, the permission of collector is required before the execution of such will. If a tribal person is transferring a land to a non-tribal person, then it simply requires the permission of collector for execution of such will. Now, question number 58. Agricultural year means the year commencing on the first day of. Option A, January. Option B, April. Option C, July. And option D, October. Question number 58. Agricultural year means the year commencing on the first day of. Option A, January. Option B, April. Option C, July. And option D, October. What should be the correct answer? This is quite common question from MP civil judge perspective. MP LRC से this is the favorite area जहां से question बहुत पूछता है definition clause से. MP, so its correct answer will be C for Calcutta, that is from July, right? Next question, question number 59. On whom order government lessee may be ejected from his land? On whom order government, yes, Ankita ji, Vinny ji, both of you are correct. On whom order government lessee may be ejected from his land? Option A, state government. Option B, civil court. Option C, revenue inspector. And option D, collector. State government, civil court, revenue inspector, and collector. So question number 59, what should be the correct answer? Yes, tell me. Question number 59, what should be the correct answer? Question number 59, its correct answer is D for Delhi, that is collector, right? So here, government lessee may be ejected from the order of collector. Yes, Viniji, you are correct. Next question is question number 60. Section dash of MP Land Revenue Code 1959 relates to and other private easement. Ankita Gupta ji, you are also correct. 59 ka D is the correct answer. Question number 60. This is the last question from MP Local Law as well as from MP Land Revenue Code. Section dash of MP Land Revenue Code 1959 relates to and Other private easement, option A, section 131, option B, section 129, option C, section 136, and option D, none of these. So question number 60, what should be the correct answer? Question number 60, 131, 129, 136, and none of these. So which of the following section is talking about other private easement? So question number 60, yes, A is the correct answer, Viniji. Now, let's move towards question number 61. That is from your Indian Evidence Act. Yes, Ankita Gupta ji, you're also correct. 60 ka A is the correct answer. Question number 61. Indian Evidence Act. The question is, opinion of an expert is, option A, supportive and corroborative in nature. Option B, relevant but unsafe. Option C, a conclusive proof. Option D, both supportive and corroborative in nature, relevant but unsafe. So what should be the correct answer? If you people have followed up section 45 of your Indian Evidence Act, you will be in the position to answer this question. Opinion of the expert is supportive and corroborative in nature. Option B, relevant but unsafe. Option C, a conclusive proof. Option D, both supportive and corroborative in nature, relevant but unsafe. So question number 61, what should be the correct answer? Yes, question number 61 ka D is the correct answer, not A. D is the correct answer because it is simply stating that both options A and B are included in option D. So opinion of an expert is supportive and corroborative in nature, relevant but unsafe to rely on a sole basis. So its correct answer will be D for Delhi, right? Now, let's move further. Question number 62. As the trial proceeds, the burden of proof under section 101 of Indian Evidence Act, option A, goes on shifting. B, may shift. C, never shifts. D, both may shift and never shift. So what should be the correct answer? The trial proceeds, burden of proof under section 101 of Indian Evidence Act. A, goes on shifting. B, may shift. C, never shifts. D, both may shift and never shift. So what should be the correct answer? Question number 62. Question number 62. What should be the correct answer? Never shifts. Very good. So I hope you people are aware that under section 101, the burden of proof never shifts, while under section 102, the burden of proof continuously shifts, goes on shifting. Question number 63. Who among us the following are competent witness? A, chance witness. B, victim of rape. C, relevant witness. And D, all of these or all of the above. So who among the following are the competent witness? This is your question number 63 from Indian Evidence Act. A, chance witness. B, victim of rape. C, related witness. And D, all of these. Question number 63. If you will read section 118 of Indian Evidence Act, you will be in the position to get the answer of this question. So question number 63, its correct answer should be D for Delhi. That is all of these. So all of these, chance witness, victim of rape, related witnesses, all of them are competent witness. Yes. Next question is question number 64. Yes, Viniji, you are correct. Question number 64. Evidence given by a dumb witness in the court by writing or sign shall be deemed to be. Evidence given by a dumb witness means a person who is unable to speak up. Okay, right? And he has given his statement under writing or sign shall be deemed to be documentary evidence, oral evidence, neither oral nor documentary evidence, and D, none of these. So again, if you people have followed up question section 119 of Indian Evidence Act, its correct answer should be B, that is oral evidence. Yes, Avi Singh ji, you are correct. It will be considered as oral evidence. Vinny ji, you are also correct. Next question. Question number 65. A statement recorded by investigating officer under section 161 of CRPC. Yes, Ankita Gupta ji, you are also correct. Can be used. Option A, For contradiction, option B. For corroboration, option C. To refresh the memory of witness, option D. None of these or none of the above. So a statement recorded by IO, investigating officer, under section 161 of CRPC, okay, that can be used, option A, for contradiction, option B, for corroboration, option C, to refresh the memory of witness, option D, none of these or none of the above. So what should be the correct answer? Question number 65. A statement recorded by IO, that is investigating officer, under section 161 can be used for contradiction, corroboration, to refresh the memory, and none of these. So its correct answer is for contradiction. Yes, A is the correct answer. Now, moving further, next question is question number 66. Presumption as to electronic records and electronic signature is given under which section? Presumption as to electronic record and electronic signature is given under which section? Option A 85B, option B 85C, option C 88A, and option D 85A. What should be the correct answer? Question number 66. 85B, 85C, 88A, 85A. This is purely a section number based question. So its correct answer will be yes. What should be the correct answer? Question number 66. 85B, 85C, 88A, 85A. What should be the correct answer? 66 ka A is the correct answer. That is your section 85B. 85B is talking about presumption as to electronic record and signature, while 85A is talking about contents of electronic records and signature, right? So question number 67. A disputed handwriting can be proved. A disputed handwriting can be proved. Option A, by examining a person acquainted with the handwriting of the writer of the questioned document. Option B, by comparison of the court, the disputed signature with some admitted signature. Option C, by calling an handwriting expert. Option D, all of these or all of the above. So a disputed handwriting can be proved. Option A, by examining a person acquainted with the handwriting of the writer of the questioned document. Option B, by comparison of the court, the disputed signature and the admitted signature. Option C, by calling an handwriting expert, and option D, all of these. So its correct answer is D for Delhi, that is all of these. Yes, Viniji, you are correct. Next question is question number 68. In a case related to the abatement of suicide by a woman, the provision of presumption is available in section dash of Indian Evidence Act. So which of the following section of Indian Evidence Act gives the presumption of abatement of suicide by a woman? Option A, section 114, option B, section 113A, option C, section 113B, option D, section 114A. Question number 68. What should be the correct answer? So which section gives us the presumption about abatement of suicide by a woman? 114, 113A, 113B, and 114A. What should be the correct answer? 68 ka yes, Viniji, B is the correct answer. Ankita ji, you are also correct with question number 66 and 67. Next question, question number 69. A and B were, yes, Ankita Gupta ji, 68 ka B is the correct answer. Question number 69. A and B were jointly tried for murder of C. During the trial, A said, B and I murdered C. What is the nature of the evidence against B? Substantive evidence, corroborative evidence, hearsay evidence, and direct evidence. Question number 69. So this will be like in simple, if I can make this question simple for you, they are simply asking that the statement given by one accused against another co-accused will be which kind of evidence? Substantive evidence, corroborative evidence, hearsay evidence, and direct evidence. So what should be the correct answer? Substantive evidence, corroborative evidence, hearsay evidence, and direct evidence. So it is a corroborative evidence. It is a corroborative evidence. If you will read section 30 of your Indian Evidence Act, it simply states that it is a corroborative evidence. Next question is question number 70. Last question for the day. That is, a dying declaration under section 32 of Indian Evidence Act is admissible in evidence. Option A, only when it is adduced in writing or reduced in writing. Option B, even when it is made to a police officer. Option C, only when it is made to a judicial magistrate. And option D, only when it is made to a executive magistrate. So a dying declaration under section 32 of Indian Evidence Act is admissible in evidence. Option A, only when it is reduced in writing. Option B, even when it is made to a police officer. Option C, when it is made to a judicial magistrate. And option D, only when it is made to a executive magistrate. So what should be the correct answer? Question number 70. Yes, 70 ka B for Bangalore is the correct answer. That is, even when it is made to a police officer. Now, let me tell you, Vinny ji, Ankita Gupta ji, it will not be C, it will be B, because in all other cases they have used the word only, and dying declaration, even if it is made to a police officer, it's admissible. So its correct answer is B. Now, Vinny ji, when I was discussing yesterday's session, you raised a doubt regarding question number 37. So I am going to discuss that particular question now in detail, right? And then we are going to sum up today's discussion, right? So this is the, if you people can see on your screen, this is section 55. And if you people can relate with that particular question, that question was, in the cases where time is not an essence, in the cases where time is not an essence, what will be the effect, right? Thank you, Ankita ji. So in this particular question, if you will read the language of section 55 of Indian Contract Act, they are simply stating, if it was not the intention of the party that time should be the essence of the contract does not become voidable by the failure to do such thing at or before the specified time, but the promisee is entitled to compensation from the promisor for any loss occasioned to him by such failure. So its correct answer will be, for that particular question, question number 37, correct answer will be B for Bangalore. I hope it is clear to you, Vinny ji, because you are the one who have raised this particular doubt. If I'm not wrong, or might be Ankita ji, someone has raised this particular question as doubt, right? If you people want, I can show you question number 37 again, or you can check it in the previous video. Okay, I can read this particular question for you. The question was, in a contract in which time is not an essence of the contract, the failure to perform the contract before a specified time. Option A, contract will become void. Option B, promisee is entitled to compensation from the promisor for any loss occasioned to him by such failure. Okay, so its correct answer will be question number 37. Its answer will be B for Bangalore. Okay, so that is it for the day. I hope we can stop our discussion here for the day. Rest of the things we are going to discuss on Monday, right? So see you people on Monday. Meanwhile, take care, stay healthy, all of you. I hope it is clear. Vinny ji, your confusion is clear now. Don't forget to like the video and to subscribe to the channel, and don't forget to check out MP Civil Judge Prelims crash course, which is having link in the description box.